I'm really very happy to be here today and to have an opportunity to open this short meeting that we organized together with the privacy camp organizers in order to discuss the problems which are right now on the agenda of all the data protection authorities, including European Data Protection Supervisor, and which drive us to the discussion with the civil society. I'm very happy of the choice of the subjects, because the privacy camp and the roundtables like that are not organized in order to preach. They are not organized in order to teach. They are not organized in order to give the statements or to present the positions. They are actually to discuss about the practical problems that we have. And let's be frank at the very beginning. These are the problems that we will have not only generally with the GDPR and the new reform of the data protection law, but also the problems that we will have between the data protection authorities and the civil society organizations. I think that might be a little bit controversial, but it will be frank to say that we will be arguing about these things. We will have the conflicts between data protection authorities, between themselves, between each of the authorities. We will have the problems between the NGOs and the civil society groups, and we will have the conflicts between the data protection authorities and the civil society groups in these two main items that we are going to discuss today. Challenges to GDPR implementation, individual and collective redress mechanism, and monitoring illegal content online, notice and action procedures. Being in my previous life quite connected with the electronic communication and electronic commerce, I know how difficult it is to deal with the practical issues connected with notice and takedown procedures and all the things connected with instrumentalization of the law in order to prepare different kind of censorships. And I will not reveal the secrets when I will say that inside the Data Protection Authority Society, including inside the office of the EDPS, there are very different views on the way that the data protection authorities should be involved in the whole idea of monitoring illegal contacts, whatever these three words may mean. So we need to discuss, and we need to discuss it now. Not when the conflicts will happen, but now when we are still in the preparation phase for the new laws are already passed and which will be passed in the nearest future, and practical challenges that we have. So I'm very happy to be here. I'm very happy to meet all of you here. I hope that will be not only the presentation, we will have not only the presentations, but first of all the discussion. We will be joined in a while by Giovanni, by the European Data Protection Supervisor. I'm the deputy of Giovanni. My name is Wojciech Wiewiorowski. I used to be the Data Protection Commissioner in Poland before, and right now I'm here in the office of the institution, EDPS, that is responsible for supervision of the EU institutions, bodies and agencies. So let's be clear, for those who do not have that much contact with the data protection authorities, we are not hierarchically over any other data protection authority in the countries of origin of you. So there are data protection authorities in all the 28 countries of the EU. EDPS is responsible for supervision of the EU bubble, but also will be providing the secretariat for the European Data Protection Board that will exchange working party of Article 29. So for us, this is not an academic discussion. This is not a discussion about the laws that we want to interpret. This is the practical problem that we will have in the nearest future. So let me then pass the floor to Sari, who will be the moderator today, and to those who will be making the presentation. And also as EDPS, I would like to thank Natalia especially and Nani for preparing the things from our side to this interesting event.
Thank you. Thank you very much, Wojciech. Thank you so much for this huge turnout. I think it's going to be very interesting sessions. what we're going to do, so perhaps I'll introduce myself. My name is Sari Depreeuw. I'm a professor here at Saint-Louis, so welcome to our wonderful institution. I'm also a lawyer and, well, in that sense, also very much interested, of course, in all the practical issues that we're going to discuss today. What we're going to do, we're having 2 sessions, so we're starting until more or less like 11 o'clock, 11:10 at maximum. We'll be discussing the issues related to individual redress and collective redress, and after perhaps well, short breathing break, we'll go on to all the issues and all the fundamental rights involved in the notices and claims. How we're going to structure it, there's going to be 2 presenters for each session. They're going to have very brief presentations, and I hope everybody will respect the brief time that has been given to them. About 7 to 10 minutes for some, well, sharing of experiences from a very practical point of view, and then the floor will be open to questions. So there's many of you here, so I hope that we can have a very fruitful debate. Then I would like to draw your attention to the fact that there's 2 hashtags if you want to engage in all these platform activities, you want to engage in a discussion online. You can use hashtag EDPS-Civil 2018 and PrivacyCamp 2018. Hashtags, 2 hashtags. So let's start with the first session. First session, starting from perhaps privacy, the Data Protection Directive, where we have no special provisions on collective redress. There was a lot of, well, burden was upon the individual for making their rights respected and enforce them in the courts of law. Of course, limited effect, of course, because, well, we see that people apparently do not care enough for their personal data to actually engage and initiate legal proceedings. So GDPR comes, then we have these possibilities, we have a reinforcement of the rights to redress for the individuals, for this data subject, explicit rights to file a complaint before supervisory authorities, file a complaint before courts against supervisory authorities, or initiate legal proceedings immediately before the courts. In addition to that, we have this possibility now to have collective redress. So individual data subjects can give a mandate to, well, not-for-profit organizations that have some kind of expertise in data protection in order to, well, have their rights respected. And even there is this possibility, if the member states allow it, for these not-for-profit organizations to initiate legal proceedings immediately. Now, what this is going to look like is not very clear yet. So there's a lot of practical questions. And it says, I'm very happy to pass the word to Javier, who has experience from the Open Rights Group.
Yeah.
Yes?
Yeah, so thank you. I'm going to stand so you can hear me at the back of the room. Probably easier. So yeah, I'm Javier. I'm from Spain, as you can probably hear, but I live in the UK and I work for the Open Rights Group, where we've been taking quite a leading role in trying to push for stronger collective redress at the moment as the UK goes through their implementation of GDPR. So for us, collective redress is really, really important because the bottom-up approach to enforcement we think is going to be critical for GDPR to be a success. So companies are right now being scared of fines, nobody really knows how it's going to work. But we think that for change to happen, we are going to need pressure from individuals to go up towards the data protection authorities and the courts, and eventually to companies to also change their tack, change their behavior. And it's and collective redress, and it's important because we've been going to the DPA in the UK many times with complaints, and they always say the same thing. Well, bring us the complaints. Where are the people affected? Where is the harm? You know, so you do need people to take action, and you need to make it very easy for people to take action. Unfortunately, we think that GDPR really, when it was drafted, has got some shortcomings, and we're trying to fix some of those now in the national implementations. So what's in GDPR? I mean, as Sari said, there is a basic statutory power that has to be implemented by all member states, where individuals can instruct certain non-profit organizations to do certain things. Those organizations are not just any non-profit. Actually, there is a quite restricted criteria, which is they have to be non-profit. They need to have public interest objectives. So they need to have a registered public interest objective in their statutes, and they need to be active in the field of data protection. So, for example, it's a bit unclear at the moment whether many consumer organizations, like the typical consumer rights groups in many countries in Europe, would be allowed under the criteria to be part of those, if they start being active in the field of data protection. That may change. Then what action? As I said before, the statutory powers cover taking a complaint to the DPA, complaining about the DPA, taking a complaint that the DPA hasn't done their job properly, including taking the DPA to court, and also to put a judicial complaint. And that's, that's quite important, because, obviously there is, at the moment, people can do all those things, but without support, from an NGO, it can be quite daunting for an individual to basically do any of those things. Now, what is really interesting, and where we think that there is a big problem with the GDPR cities right now, is that there are some extra optional powers that at the moment don't seem to have been taken up, almost by any country, to allow non-profits to do those things without the need for an individual to tell them. So an NGO can go and see something wrong, and then say, well, okay, we want to put a complaint, or we actually want to even go to court and start taking a company to court without the need for an individual to and that is very important. For example, you could, give some examples for why, but let's just say quickly, you got a whistleblower telling you that there's something wrong in a company, but you don't know any of the data subjects involved. You cannot put a complaint as an NGO, because you need someone affected. So where is the person affected? God knows where they are. So that is really, really important. So now the other thing to understand about those powers, that they're actually, there is another power, which is a power for non-profits to help people claim compensation. And those things get a bit mixed. So there is an optional power to take independent complaints, and there is an optional power to help claim economic compensation. And those things, at the moment, for example, the UK has implemented the right to help people get compensation, but not the right to take independent action, and that gets a bit blurred. At the moment, what we know is that many DPAs will allow NGOs to complain and will investigate. In many countries, and we've done, in some cases they will do it, but what is definitely not happening is for NGOs to be able to go to court, and that is where that is really a big problem. Because many cases have already been thrown out because NGOs don't have a stand. I think people from Pérez International in this room have got a few examples themselves. So why we need this? What we have found, the research in the UK shows that, from consumer group that 1 in 5 UK consumers, they wouldn't know how to claim redress following a data breach. That's 20% of people, they just wouldn't know how to go about it. And there 3/4 of people in the survey say they would definitely welcome an independent body helping them. So there is evidence in the UK that these powers are needed, and for some reason, so it's not too late. I think that many countries are now. It's probably too late for many of the implementations of GDPR for the ancillary laws, but it's not too late in the sense that these powers could be added at any time, basically. So why we need this? So our reasons for supporting independent action, independent of the data subject, is that in many cases what we are finding is that there are really complex data environments where it's really, really impossible for people to know whether they are affected. If you look at some of the online advertising, ecosystem graphs, that are there on the internet, you'll see that companies are sending data, around, and it's just really, really difficult to know what's happening. Or just know what happened with Experian, the US company that got hacked, and we know that there are several million people in the UK that potentially had their data stolen, but they don't know who they are, and they are now waiting. They are at the mercy of Experian, basically, to tell them where they were hacked. The other argument we see in favor of implementing this is to protect anonymity. So you have sometimes the data breaches which involve, for example, dating sites, where people may not want to come forward, And we are telling people that, well, if you want to enforce your data protection right, you have to give up your privacy right. You have to actually, come out to the world and say, yes, I went to an infidelity website, please help me, protect my data. So that's really bad. So we think that in many of those cases, it would be very important for NGOs to be able to take action without the data subject. And then the other point is to protect vulnerable people. We've seen from the Norwegian Consumer Council, or also in this room, that there are lots of toys, lots of things directed at children that breach their privacy, and even if they doesn't breach it directly, there are like something like 67% of children apps and services in a survey were found to be collecting personal information. Now, children really will struggle, but not only children, I mean their parents, who will struggle to supervise their children, will also struggle to understand what's happening there. An NGO can cut through all that. They can do an analysis, see what's happening with an app, forget about trying to find the children, you go and put a complaint or even take them to court. So that would be really, really important. The other thing is also in group privacy, which is a new concept that many of you have heard. In some cases, actually quite hard to put the finger on who is the subject, what is the damage, but you know that as a group or as a class, you are being affected by some process, whether it's like some crime mapping initiative, or whether it's, for example, data breaches where the value of the data or the impact is very, very small for an individual to actually be bothered to take action, but the cumulative effect of the whole breach is serious enough to potentially have systemic effects. And in those cases, it's just, you're not going to get anyone to complain. They're going to say, well, can't be bothered, but an NGO could take action and force a company to change tack. And finally, we think that it's important to bring this power because we think that data privacy and in theory at least that's been should be linked to other consumer rights, and not seen purely in isolation. And there is a wealth of experience from consumer groups, in Europe to force companies to change action. In the UK, we have a very good example around like some of financial insurance payments, where NGOs, using similar powers to the ones that we're asking, have forced pretty much the whole financial sector, to contact people and offer them like economic compensation. So yeah, so it's not too late. We are in the UK. We've been campaigning to try to get this in. We didn't get it, but we got the government to promise a statutory review of the minimal powers, and in a couple of years, in theory, they don't work as we know they should be introducing the optional powers. But we think that this is something that should be debated at least in every other country. Thank you.
Thank you so much, Javier, for setting out. Okay. We're setting out these the priorities and the importance. Now, perhaps we can go to Katarzyna for a Polish perspective.
Yes, thank you. I will try to sit down because I have things to read or check while I speak, and I'm going to keep it short because I see a lot of value in discussing this with you guys rather than with me giving updates on Polish complicated situation. But cutting long story short, we are still in the process of implementing GDPR, so we have seen the first draft of the law in September. Then we had the process of public consultation that has been finalized last week, and right now we are waiting for the second draft of the law after public consultation. So there are still those fights that I'm going to mention are still going on. Nevertheless, I think we already we can already predict what will happen in terms of implementing Article 80 of GDPR. The discussion in Poland is dominated with the fear or concerns about possible abuses of this procedure. So whenever we bring this to the public, we hear immediately from solicitors, from various industry bodies, concerns that there will be non-ethical, non-governmental organizations that come to blackmail honest entrepreneurs with claims in front of DPAs or in front of courts, and therefore we need to have that procedure very limited. You might guess that our answer is full of anger and quite bitter. I do believe that you should not limit any individual or collective redress right claiming that it will be abused. It's just absurd. But of course the lobby on the other side is quite effective, quite strong. This is probably why Polish government right now is not even considering creating a specialized collective redress procedure in the courts. So regarding civil procedure, the right to remedy under Article 79 of GDPR, or the remedy against supervisory body, so Article 78 of GDPR, here we will not have in Poland any special procedure for NGOs, which means practically that we will not be able to bring as NGOs any cases to civil or administrative courts. We will only be able to join the proceedings as amicus of the court or as third party intervening. Standard thing that has always been possible, but we will not be able to bring our own cases. A different scenario is considered for the DPA itself. So here we will have procedure for NGOs. So talking about the procedure in front of the DPAs, there will be two possibilities. One is implementation of Article 80.1 GDPR, more or less standard right to represent individual. Today in Poland there is controversy whether NGO can act as a representative in the court or whether you need a solicitor. Because of that controversy, the government is proposing to clarify that and make sure that yes, NGOs will be able to go to courts as representatives of individuals. Yes, so the Article 80.1 GDPR will be implemented or will be clarified on the grounds of Polish procedure, giving us the right to do that, even without formal paper that we represent individuals. So they propose slightly more relaxed procedure, saying that if there are two conditions fulfilled, whether this is justified by our statute, our mission. In case of Panoptykon, it's clear that our mission is to defend data protection rights, and whether it is justified by the individual interest, and there is individual that we can name, but not necessarily we have a legal, power of attorney. We don't need this legal document in hand to do that, but we need individual that we can identify, her or his interest, we have to prove, and our statutory goals. If all those conditions are fulfilled, we can go directly to DPA and even start the case on behalf of this individual, or join the case as third party to support individuals. So that will be clearly stated in the law, but that's nothing revolutionary, and I would be extremely surprised if we didn't even have that, right? It's more complicated regarding Article 80.2, so what you call collective redress, or in Poland we rather refer to social interest, so an NGO being able to represent social interest rather than represent certain individual. Here, the new Polish law implementing GDPR says nothing about that possibility, but we have existing administrative procedure, the Code of Administrative Procedure, which in Article 31 says that there is such a possibility, and government confirmed that this is also their intention to actually use the existing procedure for that. Let me double check what exactly that code says. It says that an NGO can start the case not in the case of individual, but not on behalf of individual, if this is again justified by the organizational statute or mission, and if there is a social interest in it. Yes. So theoretically, in practice, it's not used very often, but theoretically, we can go even today, even without new law on data protection, we can go to DPA, not to the court, but to the DPA, and either start the case in social interest, or we can even be notified by the DPA that there is a case interesting for us running, and join that case. Yes? So those not collective redress procedures, but the procedure enabling NGOs to act in social interest in Poland are already in place, and the intention of the government is to keep basically those old rules and enable us to start cases in front of the DPA. So this is more or less the Polish landscape here. My biggest regret or concern is not what will happen in front of the DPA, because here I believe we have a clear procedure to act, but lack of any procedure for us to bring cases to courts. So to those places that will be able to give remedies to individuals, and who will have much more impact on individual cases, in fact. Because that's how I understand the value of GDPR, that individuals will be able to get remedies for infringements in data protection, and not only have satisfaction that somebody has been fined, but they got nothing out of this fine. So regarding Articles 78 and 79, unfortunately, there is no progress in Poland, and we will only be able to join those cases as amicus of the court or third party, but not be able to start those cases.
Yep.
Yeah.
Okay, thank you very much. So I think we have a nice overview now of the important issues, the important questions. We have a Polish perspective and some procedural questions, very important for practitioners, of course. Now, let's open the debate up to your experience, perhaps. Anyone who wants to raise a question, any particular experiences you want to share?
Yes, I think it's...
Could you please introduce yourself?
Yeah, I'm David Korteweg from Bits of Freedom. Just want to briefly say something about the situation in the Netherlands, because I think it's relatively unique in the EU. We have a fairly liberal system in the Netherlands to actually initiate legal proceedings as an NGO or as a foundation. And that is actually not limited to, say, data protection. It's actually with regard to, well, any rights, or at least a lot of different rights. So, and that's already for several years. So in the Netherlands, as a foundation or NGO, you can say initiate a civil. You can go to the civil court without actually having the requirement to represent actual individuals. As long as the statutory purpose of your foundation basically is, for example, protecting privacy rights. I mean, it has to be a bit specific. There's some like threshold, but the threshold I think is relatively low.
Have you done so already?
Not with regard to data protection, but for example, we can also go to the the DPA or another supervisory authority, and for example, we've done that recently to enforce the net neutrality regulations in the Netherlands. So we can go to a regulatory authority and request them to basically enforce the law. So that is one way you can do it. And what Kasia was saying about the fear of, or the opposition that she's encountering in Poland about like, oh, this will be abused. I think the Netherlands is a good example of a country that has a very liberal system already for several years, and in my honest opinion, it hasn't been like abused in massive ways, or not abused at all, I think. So I think that could be a good example for people that encounter a lot of opposition in other member states too.
Is it possible for you to ask for damages on behalf of individuals?
Yeah, no, there's a limitation on that. So you can ask, so if you go to a civil court, you cannot ask, well, you could ask damages if you would, well, no, you cannot ask damages if you, say, just represent a public interest. There is a proposal in the, it's still waiting in the parliament to introduce, say, collective redress with regard to damages. But you can ask for like an injunction or a declaratory judgment, which I think, especially in the privacy, especially for enforcing privacy rights, I think that is already a very powerful tool, because you can basically block certain practices or get a declaratory judgment that the law should be interpreted in a certain way.
Yep.
I just want to follow up on what you were saying, because it's really important.
Could you introduce yourself? So
sorry, it's Anna Fielder. Just to follow up on what David was saying, because it's really important, and also Javier mentioned it, that around Europe there's been a lot of consumer groups taking cases to court on the basis of consumer protection law, also in cases related to digital businesses. There are several countries like Netherlands that have comprehensive collective redress, not just for data protection, but for everything. For example, Portugal has a very good collective redress system, Belgium, Italy, I believe. So I think it's a very important discussion to be had, whether we continue to fight for this Article 82, which almost no country has implemented, or whether it is, you know, at European level, more important to fight for a collective redress. European, there's an EU recommendation on collective redress. Maybe what we should do is fight to introduce the collective redress as a directive or regulation in the EU, and that will solve everything.
For all consumer cases, not only data protection.
Yeah, it will solve, you know, net neutrality and data protection along with all the other cases. So that's just a thought.
Hi, Fanny from Access Now. And I think there's another element which we really need to push back on, and that's the abusing of a mechanism to enforce your fundamental right, which was a typical narrative in Hungary about freedom of information, actually. When they introduced, it's a form of refusal, it's a ground to refuse a Freedom of Information Act request, when the authority can claim that it's abusing the right to freedom of information.
You mean acting against the government because they will not provide this
Yes.
possibility in procedural law?
Yes.
Yeah. Could you explain this a bit further, like the reasoning?
Well, there's not much legitimate reasoning behind it. It was just a political act to suppress this right.
Yeah, but why not?
May I just add something to Fanny's remark? I'm Eva Shimon from Liberties, Berlin-based NGO. So what we can see now, and I think that's what's interesting from the Polish perspective, and that's what Fanny was referring to, is that the shrinking space for NGOs, what we call. So in some of the EU member states, what governments do is that they try to limit and push back NGOs' attempt to enforce any kind of fundamental rights, among others Hungary, Poland, but we can also mention Ireland and also at some points Italy as well from the migration perspective. And if the governments try to push back and limit the NGOs' possibility to enforce specific fundamental rights, we can end up with this argument, and that's what was Fanny maybe referring to. So it's not only a Polish situation, but we can see it's starting broadening all over Europe, or at least some parts of Europe, to blame NGOs for certain political issues.
I will only like to clarify the fear of abuse in Poland, at least. It's not so much related to the actual cases, because whether the actual case brought by NGO will be allowed, it is a decision ultimately of the DPA in our case, because we are not discussing courts, we're discussing DPA procedure. The DPA will be the body saying, checking whether there is a social interest behind it, whether it's not abusing the law. So this is our argument against the government's argument that why do you fear, since there's always a public body between us and the procedure saying whether we are trying to abuse it or not, right? It's not automatic. We cannot automatically trigger Article 80.1 of GDPR and simply bring the case. We need somebody to acknowledge, yes, you have the right to do this because it is in line with social interest. Sorry, Article 80.2. But then they come with another argument saying, no, we are not actually afraid of cases brought by you. We are actually afraid of you going to business, talking directly to companies and threatening them directly without going to court or the DPA, that you will do that. And we have experience of that in consumer law, actually. There were many events like this in the past on the grounds of consumer law, apparently there were cases of ecological organizations doing something like that. So addressing companies directly and saying, you have to, I don't know, pay me money or order a service from my NGO. Unless you do that, I will bring that to court, I will bring that to the administrative body. So the blackmail that they bring against us as counter-argument is not actually about bringing the cases, but about going to companies and blackmailing them that we will do that. In my opinion, this is completely absurd, because that can be addressed by simply informing the companies that if they act legally, they have nothing to fear, right? If the company is not acting against the law, why should they be afraid of any organization starting any case on behalf of any individual? So my argument here usually is that if we have so many companies in Poland who are so afraid that they are actually in breach of the law, that they will pay money to anybody on the grounds of such conversation, it's clearly the problem with companies, not those organizations. But the argument doesn't really concern the cases brought by us, but the conversations between companies and NGOs.
I add something on the collective. Why Anna's proposal I think is important. Something that is the difference between the opt-in or opt-out class actions. I mean, the things that even with the most optimistic in the implementation of GDPR, to get economic damage, you still would need to be instructed, so you wouldn't be able to implement a proper opt-out mechanism where an NGO can claim economic damages on behalf of a class, and then get. So I think that it would be quite important to really have a full collective redress, and I think that's true. I mean, GDPR in itself does not provide, even in its widest provision, does not provide the full collective redress that would need to be created.
Okay. Does anybody have perspectives to add? Any thoughts on evaluation of damages, perhaps, or representation of?
My name is Jesper Lund from Untitled Denmark. So I have a general concern that sort of the definition of damages in some countries, and in particular Denmark, would be so limited that it would be of relatively little value for, say, data protection issues. The Danish government, so specifically the Danish government is arguing that even though GDPR says material and non-material damages, so this non-material damages should be interpreted in sort of consistency with member states law, not necessarily European Union law. And Danish courts have generally been very reluctant to award damages unless you can prove a direct financial loss from the action of the other party. And this may be difficult in, say, a data breach case. You are one of 100,000 persons whose information has been leaked by a data broker, but your personal data hasn't been abused for fraud yet. So how can you prove a direct financial loss in cases like that?
Have you come up with some kind of construction to evaluate?
No, not really, and it's not really been a big discussion issue in Denmark. It's just sort of Danish government is generally trying to sort of say that the GDPR means as little change as possible compared to the current regime, including for damages. So if that situation is similar in other member states, that could be hurdles to using damages, and it would be useful if sort of damages, especially non-material damages, was to be interpreted in a European, in a harmonized European way. It also makes sense.
But I think this is an issue of that many European countries struggle with, that there's no type of punitive damages in the continental system or in the European system. Has anyone any experience with alternative systems for this type of punitive damages, or making it worth a while? No, not in UK.
It has to be related to a specific.
You have to prove your actual damage as an individual.
Well, in any dispute, the damage, the compensation has to be proportional to the actual harm to go over.
Yeah.
So you end up having to prove individual harm anyway, even if you represent social interest.
Yeah.
Either you show harm to individuals, or you have no way of getting any redress.
Yeah. But perhaps there is an interesting experience from copyright, well, in the copyright sphere. Because in copyright, of course, there's a lot of experience with collective management organizations, well, collective organizations that represent individual authors, that have come up with this type of standardized rates, well, legitimate or not so legitimate. There's always a big debate about these evaluations, but perhaps there could be an effort to come to this type of tariffs, maybe?
Well,
Any thoughts?
The problem there is that if you were to use the analog of what's done in the copyright infringement sphere, is you would end up with the resale value of the data that have been, let's say, wrongfully processed. And if you look at the typical value of, let's say, a medical dossier among data brokers, then you'll end up with pretty small amounts actually. The data is typically exchanged against monetary compensations among data brokers for remarkably low prices.
But that's the thing, like in copyright, the reasoning often will be, okay, this will be the basic amount, and then you start counting the infringements, okay, infringement of this right, infringement of that right, and you can get this effect of doubling, just describing, I'm not
as
defending,
someone from
but
an
this
NGO that actually is very much opposed to that way of calculating damages, I would never advocate that for data protection issues. Then it would be very hard for a lot of people in NGOs to press for that argument, just from a technical perspective.
From a
technical perspective, because we typically argue against that kind of reasoning when it comes to copyright infringements, and then we would use the same argument in favor of data protection.
But the difficulty, of course, that copyright clearly has this economic component of tradability of rights, which is lacking from. Yes.
Sorry, I'm Bailey from Purpose International. I just wanted to add to Javier's comment about what the situation is in the UK. Under the current DPA, it said that it was interpreted that it would only be pecuniary damages, so not for distress. And a couple of years ago, the Court of Appeal declared that that was not the case, that it was for distress as well. So recently in the UK, there's been one of the first class actions in terms of kind of data protection, and that was a supermarket that had a big breach.
Could you speak up a bit?
Oh, sorry. There was a supermarket called Morrison's.
A supermarket.
Had a massive data breach, and a case was brought on behalf of about 5,000 employees, and that it's going to be appealed. So they have delayed the quantification of damages. But I think that's going to be an interesting case, at least in the UK, to see how that is addressed, because the amounts actually given in the few data protection cases that there have been relatively high for distress, and because there's not enough litigation on it so far, a lot of things are settled out of court. So I think that there's still not enough clarity, but I think that's going to be an interesting case to watch, because it's very clear now in the UK, and there's no discussion in terms of implementation of GDPR that there will never be damages for distress. There's clearly going to be damages for distress, and that's no longer a question in the UK.
Okay, thank you so much for this perspective. Now I think it would be good for us to move on to the second session, unless there is someone who really needs to get something off their chest. No? Okay. Then let's discuss our second subject, which is about the notice and take down, the actions, well, the fight against illegal content on platforms. Now, the Commission has taken a number of initiatives to tackle the presence of illegal content online, and so far our legal framework consists mainly of the e-commerce directive. We have a very clear principle: an intermediary, an ISP, can escape liability for the presence of illegal or harmful content on their platforms, provided that it has no knowledge, and if there is knowledge, it takes down these procedures, this illegal content quite quickly. Now, there's no general obligation of monitoring on the intermediaries, and that's quite an important principle. But of course, we're confronted with a whole bunch of, well, content, a lot of expressions, information that is not necessarily desirable on these platforms, and we can think of a whole variety of harmful content in this sense. Harmful content that is not strictly illegal on the one side, and then illegal content we can think of, well, copyright infringement, counterfeit medicine, consumer goods, we can think of defamation, libel, slander, racist speech, hate, incitement to hatred, and we think of, well, third category maybe, terrorism and child pornography, where mostly I think people can agree it's not so difficult to identify whether or not there's illegal content. Now, this is a concern for the Commission, and they have come up with this 2017 communication proposing a number of measures to be taken by the platforms themselves in order to make these networks a safer space in their opinion. Now there's a whole bunch of questions to be raised and a number of concerns to be raised, which will be discussed by Maryant and Fanny. Who wants to start? Maryant is going to start. You're going to address the measures proposed by the Commission.
Yeah, basically the big picture. So thanks so much. I'm Maryant. I work for European Digital Rights EDRi as a senior policy advisor. It's a pleasure to be here with you and following the previous format. The idea is to discuss because most of you are already aware of this, and those who don't, I hope that what Fanny and I will present will clear in your minds. So on the one hand, we have a trend towards pushing companies to do more on several public policy objectives, as it was mentioned before. And then so we're asking, and not all companies, but only the big platforms to become the legislator, the executive and the judicial power of the internet. And that's what we call in EDRi privatized law enforcement. And to be clear, what they're being pushed for to do is not to implement the law. What they are pushed for to do is to implement their terms of service that were drafted by them. They're not, as you know, democratically elected bodies. And contrary to legislation, whether we like it or not, is drafted by them to basically avoid any type of liability. So in the current picture, we not only have like the basic e-commerce directive, we have many legislative and non-legislative initiatives. We can name a few, like the terrorism directive, the Europol regulation, the ongoing discussions on the audiovisual media services directive. We also have the copyright reform that is also ongoing. We also have the hate speech code of conduct. In relation to the framework decision on racism and xenophobia. We also have different member states' laws, as the most famous one currently is the German NetzDG, that, as you know, has many problematic issues. And you mentioned before the communication of the Commission on tackling illegal content. From our perspective, there are several issues with this communication. The first is that the assumption that we can solve everything by technology. So there's a trend towards regulation by algorithm. So if you hear the claims by certain parts of the Commission, it's assumed that if we ask the giants to take care of what we do online, developing some technical tool, will solve hate speech online, will solve terrorism online, and so on. Then there's no effort at all to know and to assess really what type of content is being removed. There's obviously, if you're a big company and then you're being threatened with public relation problems, reputation problems, and also faced in cases, for example, like Germany, of sanctions, you may want to delete all the referrals that you've been that you're being referred to, right? And then so if you're especially a smaller company, you would not even have the resources to make legal assessments about whether the content in question is actually legal or not. So there are some questions that could be asked. One is the removal of a tweet the solution for terrorism online when the removal is subject to the voluntary consideration of big platforms on the basis of the terms of service and not the law? This is Article 4.1m of the Europol regulation. Is framing 6 tweets as glorification of terrorism when actually making politically sensitive statements a solution to fight against terrorism online? This is the Cesar Strawberry case in Spain, as ruled in the Supreme Court, where a rapper was sentenced to prison because of putting 6 tweets that, by the way, are now being disclosed in the press. So is the press also glorifying terrorism? Are we really solving terrorism by putting people in prison? Third, is the solution to terrorism online to state in the law that if you glorify terrorism on the internet, automatically this means that the sanction that you would receive is higher as if you did it offline. This is actually a provision of the Spanish criminal code, and I put the Spanish examples because I'm Spanish. But we could make many other examples from different member states. The most salient ones are France in Spain, but many others as well. So the current framework is designed for everybody to be exempt from responsibility. And so, in my view, it's just a public relations theater to see who removes more and more quickly. And so if we keep regulating the internet just for the big giants to decide what we do or not to do or what is right or wrong, then the internet will become just the internet giants, because even the Commissioner Jourova was asked just yesterday in the context of hate speech, so what about smaller companies? Are these giants willing to share their magical technological tools? And they said yes, of course, but this is not charity. Because the big ones that I'm quoting know that if the small ones will spoil this, the legislation will fall on all of them. So basically we don't have any interest in the non-giants to actually even take action. So the focus is really on PR theater, on who removes within 24 hours and who removes more. And not to actually solve the problem. And so these are like the freedom of expression concerns, broadly speaking, but there's also privacy and data protection problems. For example, the EDPS already in 2013, so 5 years ago, already stated that notice on action procedures may imply the possessing of sensitive data, especially if you're dealing with potential criminal offenses. The EDPS also made some recommendations to take into account privacy and data protection legislation when dealing with illegal content online, for example, the confidentiality of the notice provider and the other persons involved. So we could ask questions such as, is the so-called trusted flaggers and the big companies having an encrypted channel or a secure channel to actually exchange potentially criminal proof before a court? The answers we're getting from EDRi is no. And there are many other recommendations that have been made in the past that are not being simply put forward because there's not the political will to actually make a change. However, to be a bit optimistic, on the other hand, there's a very good trend towards making things right. So the Council of Europe has made several recommendations on both privacy and freedom of expression in relation to intermediaries and the obligations of both states and companies. And these are quite good, broadly speaking. You have also the UN Special Rapporteur, David Kay, that is putting forward several recommendations to go into the right direction. You also have several members of the European Parliament that are also trying to make things right. But we need to really make sure that we can use this political momentum, let's say, to change it. If you look at EDRi's website, you see that a decade ago we were arguing the same things, and we are not changing. So I wonder, do we need maybe freedom of expression law as we have privacy laws? Do we need to check, as other experts are exploring, if we perhaps, instead of focusing on freedom of expression, check whether there's any other implications, for example, on freedom of thought, because it's an absolute right, contrary to freedom of expression. Is there a way that we can really move forward and then move from a PR perspective, which would only benefit the giants, as Commissioner Jourova likes to frame it, or to find a solution that actually brings change? Obviously, as an individual and as a part of a society, I don't like terrorism. And as living in Belgium, you see that we are quite affected. But that doesn't mean that anything is the solution. That doesn't mean that just removing the content without assessing that this has any counterproductive effects is a solution. That doesn't mean that if Google and Facebook and Twitter take the lead, we'll solve the problem. So we're just asking for some diligence in this sphere.
Thank you so much for this. Fanny, what do you have to add to this warm expose?
Thank you very much. My name is Fanny. I work for Access now, and I apologize. I have a sore throat, but I'll try to speak up. So, among the many issues Maryant discussed and told us about the push to do something, I chose one which for me represents one of the biggest bubbles without any specific grounds, and that's the push to do something about fake news. I chose this topic for 3 reasons related to this session. The publication of 2 very recent studies, 2 changes announced by Facebook very recently, and the Commission's high-level expert group that just been set up. So I will start with the question of the problem definition and why and how and what are we talking about when it's fake news. And obviously this is nothing new. I love the example of Article 19 dug up an English King decree from 1647 on fake news. It looks great. I'll share after. But to be honest, why we're talking about this is a political pressure about the US election and to a lesser extent about Brexit. So there is a push to do something, when in fact, when we have started reading investigative journalistic reports about the Russian government or oligarchs close to the Russian government directly funding far-right parties in Eastern Europe but elsewhere too, there was push to do nothing. So why the difference? The two recent studies that were published, one of them is from Stanford, the other one is from Dartmouth College. And the authors, of course, have several caveats about the conclusions they make, and I'll try not to fall into the same trap as some of our colleagues on the business side usually do when they quote these studies. My favorite one was about how e-privacy hinders innovation. There was one caveat that they could not close out any other factors or legislations that led to the same hindering in the innovation. But yes, so the studies looked at consuming news online. One of them excluded social media, which is probably a big caveat, of course. The other one did include social media, and they both concluded that fake news had probably very, very little to impact the outcome of the US election. And the main source of political information is still TV ads. They give us a ratio how to compare the exposure to fake news as opposed to a TV ad, which might just be as propagandistic, I would say. They say that in order to have any impact on the election, a fake news story would have convinced about 0.7% of Clinton voters or non-voters who sought to make the shift. And they make a persuasion rate equivalent to seeing 36 television campaign ads. The huge question is what they use as a benchmark, how you believe in any of those, and how that persuasion happens. Based on the surveys, people visited, one in every 4 person visited fake news websites, and they define fake news websites based on only sources that came to life in order to spread that type of information. So they exclude Breitbart, for instance. The funny thing is, though, that literally 0% has checked fact-checking sites or counterclaims when they searched or found fake news. So it puts into question the upcoming approach of the Commission when they focus a lot on fact-checking in the future. Moving on to Facebook's 2 new changes very quickly. One of them, as you probably have heard, that they will deprioritize news from media and organizations, and they will prioritize friends and that type of content. And Mark Zuckerberg said that this would probably lead to people spending less time on Facebook, but that's a sacrifice he's willing to make in order for the experience to be more valuable. Well, it's definitely going to be more valuable. The question is for whom? Because online marketing experts, salespeople started to look into the impact of that change in the algorithm, and they can find 3 ways. Either there's no change, The second
In the algorithm? Or
no, in the ad revenue and how price of Facebook ads will be impacted by this change. The second one, if you spend less time on Facebook and related ads, it means that there would be less total supply, and well, that's just a very basic logic that the price of Facebook ads will increase. And only the players who you also mentioned, the big players, not necessarily the same ones, will have money to afford those type of ads. And the third assumption, the third approach is that there will be a collective loss in organic reach, which entities will have to combat, and that will mean a larger total demand for Facebook ads, leading to the exact same conclusion: Facebook ad prices will go up.
Is it established that there will be less?
These are assumptions based on people who are doing social media marketing and try to sell you packages of how you advertise on Facebook. But I think obviously these are very preliminary assumptions, but both lead to Facebook benefiting from those changes. So finally, to finish up, there's a new fake news expert group being set up by the European Commission. Congratulations to Depreeuw, who made it to the expert group. We are not so lucky, many of us in this room, and including David K. For instance, many freedom of expression groups have been rejected, and there's a general lack of transparency. And there's one interesting part of the timeline of the fake news expert group, because there's a parallel public consultation, but the timeline of the push to do something won't allow the public consultation to be taken into account in the outcome of what the Commission is proposing. Thank you very much.
Thank you so much. Very enthusiastic, yes.
Jeff Chester, Digital Democracy. Fanny is right. The reaction from U.S. ad tech experts is this is a move by Facebook, so it will force the global big advertisers to buy more advertising because they no longer will have that so-called organic reach. So it's about boosting Facebook revenues and boosting Facebook's expansion of video advertising, video marketing.
Thank you so much. Yeah, it's a very rich subject. I see issues of fundamental rights, balancing between fundamental rights. I see issues related to the role of courts and private actors, or even law enforcement. There's economic issues as well. Who wants to add anything? Yes.
So, as a general plea for accountable, democratic, law-based approaches, if the Commission does something by law, it has to respect the Charter. It has to be able to show that it's predictable, that it's necessary, that it's proportionate, that it genuinely achieves objectives of general interest. Ad hoc, arbitrary, please do something, guys, it would be nice, we can put out a press release, has no review mechanism, has no impact assessment, has no assessment of durability, has no assessment of counterproductive effects, has no assessment of anti-competitive effects, has no impact on the privacy effects. And what you just said, Sari, is really interesting on the balancing, because it's a network, so a simple balance is rarely there. So in the Delphi case, in the European Court of Human Rights, somebody uploaded defamatory comments. The provider, the newspaper removed the content quickly when they became aware of it. And the court said, no, you need to be able to identify the individuals so that they can be blamed for what they do. Well, what are the options for a newspaper to identify their user? Oh, they can use Facebook's free identification tool. So you start off with freedom to do business and defamation, and then you end up with a third element. If you're going to impose that liability, then you end up with the privacy infringement happening accidentally, and that three-sided balance was never assessed. Austria is about to refer a case to the European Court of the Court of Justice of the EU, whether Facebook should be required to prevent on a global level the availability of certain defamatory / hate speech comments. It looks like a balance between Facebook's obligations and the rights of the individual who was defamed. But if you ask for prevention, then you're asking for additional data processing by Facebook. And then you've got the privacy of everybody who's having their data filtered. So it's a privacy issue and a defamation issue and a freedom to do business issue. And also, and this is fundamental in this whole area, you can use the law and you can use public relations to push the companies to do more. They have a legal obligation not to do too little, but they have no legal obligation not to do too much. They have freedom of contract. You can push them, and they will delete more and more. It's actually quite easy to press delete. Defending freedom of expression and defending privacy in that environment is tremendously...
Well, this is the thing that struck me as well in this communication of the Commission. Well, we have this general principle of, well, no general obligation of monitoring, but now all of a sudden there's an obligation to provide a lot of mechanisms. You have to have a mechanism to monitor, the mechanism to remove, you have to mechanism to profile even the users and have this preemptive approach, which is quite interesting because it means that your general monitoring will not be done by the network but by the users of the network, which may come down to the same thing, maybe. Any thoughts? How about this, one of the problems that may be there is of course that, well, the courts have established a number of tests. So we have the Court of Justice, for example, in cases, the Promuzikai case, for example, balancing between copyright and data protection, where it states, well, there needs to be a fair balance between these fundamental rights. It's difficult to establish a more precise test, of course, but how will this be done by social networks, by these platforms? How could they do this in practice? Any thoughts?
I'd say there's no mechanism to require them to do it.
No.
There cannot be a mechanism to require them to do it. They can be given liability, they can be given PR pressure, but you can't stop them. They have a balance of incentives. Either you create, which is tremendously difficult, a balance of incentives for them to leave content online or to take content offline that hits the provided for by law standard of the Charter, or you don't. And if you don't, you are undermining the rule of law and democratic freedom of expression rights for European citizens with global effects. And the AVMS and the Copyright Directive are going to have global, really detrimental effects for freedom of expression and democracy around the world. And
but then the Commission also included in the communication, there needs to be mechanisms to put content back on. So if the poster wants to exist, that will be the counterbalance.
Where there's no obligation. The Commission would like this.
So I think it's the refusal of governments to take responsibility and bring any measures under like strict human rights framework, and that is one of the fundamental problems. In the UK we've been hearing that there's a general trend. They want to force companies to do something. So for example, in copyright we mentioned there is an agreement between the City of London Police and advertisers, where the City of London Police provides a list of potentially infringing websites for copyright, and advertisers take measures. Now, you ask the advertiser to say, it's the police that gave us the list. And you ask the police and they say, no, we're just giving them the list, you're not telling them what to do with it. And usually we've spent now like several years trying to untangle that. and there is just no one takes responsibility. And I think that is like the perfect example of what we are where we are heading.
So nobody takes a stance, it's just suggestions and implicit messaging.
So the police will give a list of websites and say, you know what to do with this, and the other. So when you ask them, they say, well, we didn't tell them to do anything, you know. And then when you ask the advertisers, they say, look, the police gave us a list, you know. And of course, you know, we have to ask you, need to ask the police, you know, if you want to clarify. But no one, I mean, it is literally impossible, like a complete and accountable system, and that's what we are seeing. I mean, that is really the model that we are seeing now.
Any other experiences? Anyone wants to share?
I mean, the same model is replicated at the EU level in the Europol regulation. I mentioned it briefly. So with the creation of the Europol regulation, we have an EU Internet Referral Unit, where Europol needs to refer content to the platforms, and then is subject to the platform's voluntary consideration to deal with this content. And so when you go to expert meetings, for example, I was part of an expert meeting in the Parliament, where Europol was presenting and just complaining because they didn't have enforcement power over what the companies can do with it, but obviously there's no assessment of legality in that process. However, their national internal referral units are trying to implement best practices, and Europol apparently is not helping these internal referral units to actually establish them. This is the case, for example, of the Netherlands, where some step forwards have been happening, and to assess the content not on the basis of terms of service, but the actual law in the Netherlands. So this is a good practice that is not being put forward. But we could learn from best practices and maybe try to really make sure that everybody takes responsibility, not just like the big platforms, and that's it. And that's the end of the story.
Has the EDPS commented on this, on the privacy implications?
Yes, repeatedly. I will come back to this point. So maybe
on the content note, something that you said at the beginning, that there were some, when we look at what kind of things are being blocked, I mean, you said that sometimes there are some things that are very easy to, and some that are harder. I mean, we take a little bit of issue with that, because what we are seeing, apart from the very worrying trend towards proactive, pervasive monitoring, the other things like the expansion of the things that are covered. So in the UK government has been trying to implement restrictions on extremist content for several years, what they see as like the precursor of terrorism. So they say, well, in Muslim teenagers, they start talking about radical Islam, they get radicalized, before they do anything terrorist, they are being extremist. And of course, they cannot make an anti-Muslim law because that would be discriminatory, so they're trying to define extremism in the abstract. And it's just impossible. They just struggle, they've tried years and years, and there is just no way that you just cannot define them. They talk about being against British values, against democracy, against, but it's just really, really hard.
But this whole glorification of terrorism is very difficult.
So that is, So for example, in Facebook, anything to do with the PKK colors, will get your website taken down, because the PKK is a proscribed organization. Ireland is a signatory to lots of UN treaties, and because Facebook is in Ireland, there is anything with the PKK can be taken down with the colors of the PKK. Glorification of terrorism.
Do you know why they do this? Is there some kind of contact between a government instance and
Facebook?
When
someone from the Turkish government contacts Facebook in Ireland, or the EMEA, I think they take down the content automatically. But and then on terrorism, I mean, you say sometimes it's easy, but actually a lot of the content that we see, if you look at some of the speeches of Anwar al-Awlaki, the cleric that was vaporized by the US in Yemen a few years ago, and his 16-year-old son as well. I mean, a lot of the stuff he was saying is quite outrageous. A lot of the stuff he's saying is just like radical Islamic politics, with no call for terrorism or anything. I mean, it's just like a very, very thin line. There is stuff that is simply Islamic songs and things that are cultural, are part of the culture of ISIS. It's like not calling for anything, but it's just like the same way that hip hop and gangsters, in the US go together. In some cases, and that stuff that is being banned as terrorist material right now. So I think that is actually really, really tricky to draw a line, and same even with child abuse. I mean, Wikipedia got shut down because they had the front cover of a record that had a 12-year-old naked girl in the front page, and the whole of Wikipedia got shut down for child porn. So, I mean, it is really, really tricky until you get to a court and there is a clear ruling, you are in a gray area, basically, for anything.
It takes a very long time.
Yeah, and I totally agree with that it's very difficult, and if we give it into the hand of these big giants to decide over our fundamental rights, that would cause a big problem. And it's not only related to free speech and privacy issues, but all the others as well. So when what we find very problematic from the fundamental rights perspective is that we are and what the EU is doing is just pushing liability towards these big platforms and asking them to introduce mechanism and non-transparent mechanisms. So I mean, we know nothing about what they remove, when they remove, and even that those very controversial issues like the Delphi case, which was mentioned, and later on the European Court of Human Rights in a Hungarian case decided a bit differently. That shows that at different level, different courts don't even agree where to draw the line between free speech and defamatory or other, or even hate speech issues. And when we ask these platforms to decide, they would say, no, we are censoring, we are deleting, and we are removing, and no individual has the strength to go for and push for the, after taking down certain content, to upload online again. That is I mean, there is no
Burden
balance
shifted
between
to the detriment of
the
individuals, yeah.
players.
Anyone else? Perhaps a last comment? Questions?
No, I'm just wondering where should we draw the line as network of advocates here, and maybe proposition would be that, okay, notice and takedown, it's a good mechanism as long as there are individual rights involved, or as long as there is specific harm you can prove, even the bloody copyright. Okay, we don't love it, but we understand it can be established that there is somebody's harm. Of course, privacy is something that I would be always in favor of using the takedowns for privacy infringements, but usually you have individual, even hate speech, you can establish, if not individual, then collective harm of certain group. But all other types of content, like nudity or fake news or whatever will come next, should not be at all considered for this procedure. Maybe if we try to establish as a network some kind of red line and try to advocate for it, we might be more effective in stopping this madness that will be, dragging more and more types of content under the procedure that I think we endorsed some time ago as good tool to, for example, protect privacy, but it's not effective tool to protect other societal interests.
Yeah.
I think we need a criterion that we can express.
For us, one of the lines that we found important is the mechanisms for social media to have mechanisms to deal with abuse. I mean, in the UK, in other countries, but the UK, I mean, particularly women on Twitter, they get systematically harassed, and there seems to be, like, on the one hand, like this obsession with dealing with terrorism material, and then you see women, getting like rape threats constantly, and then nothing happens. So I think that imbalance or starting, that would be a good starting point, and then from there you can maybe build an accountable system with due process and start taking that.
Okay, thank you so much. If nobody has any pressing comments anymore, then perhaps we can move to Giovanni for the closing remarks. Thank you so much.
Thank you, Sari. Thank you, Javier, Katarzyna, Kaja, Fanny, Maryant, and all others contributing to this, let's say, annual tradition. The last one was actually in May 2016, but it was let's say, a more restricted audience. We now see a bigger one, good friends from outside the EU. So I think we should continue looking forward to, let's say, reinforce this tradition, to go beyond the 2 excellent hours we dedicated to a couple of very important items, and perhaps provide for, apart from regularity, an opportunity to, let's say, identify conversion lines of action with full respect of what we do as, let's say, independent supervisory authorities and, let's say, civil society. So, once again, thank you for your active dedication, passion, and engagement. The issues you selected, as I said, are of the utmost importance of the EDPS. Of course, I will start by referring to the issue of collective redress mechanism and damages. Needless to say that all victims of data protection and privacy violation will suffer a lot of damages, not only financial or reputational, but also in a few cases emotional, psychological, should, let's say, be able to have an effective report for an effective remedy. This is not only an obligation because of Article 47 of the Charter, but it's because, let's say, de facto, because of the essence of the new legal framework on data protection. The emphasis is now around Article 80 of the GDPR. GDPR as a whole is not the ideal piece of legislation we may envisage, but it's the best we can achieve today, even if we start once again after 4 years of negotiations. The right to mandate, yes, it's an important paragraph 1 in Article 80. You know that we have been pushing for something more. Paragraph 2 of Article 80 represents a compromise solution, so the idea that you may lodge a complaint as initially proposed by the Commission. It is not exactly what we had in mind, but it's a good starting point, and perhaps the trilogue around the privacy regulation may offer a real collective redress mechanism in such a specific area. Who knows? I think it's time we cooperate more in following the legislative developments at member states level, including the implementation of Article 80. Signals coming from Germany, UK, and Italy are not encouraging in that sense, meaning nothing new in addition to the right to mandate and the right to lodge a complaint, although the right to lodge a complaint means the right to be heard, the right to be informed in a reasonable period about the outcome. It's time for all of us, including the EPS, to send signals to data controllers in terms of accountability. I would really love you to start being, let's say, more engaged in the digital clearinghouse exercise. I've been following your comments about the specificity of privacy and data protection as compared to other consumer protection rules, and I think the exercise we started on the petition not only relates to antitrust, but also to the idea that consumer laws should not work anymore in silos as well as data protection and privacy. So that's an exercise, that's a forum where we may really have, in addition to this practice of the summit, to share ideas and identify a solution for possible, let's say, incentives to the legislation. The signals I envisage should be, in my view, more coordinated, more strategic. This is not a criticism, but this is time for the civil society approaching the full implementation of the GDPR to be more visible, to be more selective, to be more strategic, and to coordinate actions, at least in Europe. The 20-hour working party has adopted a huge number of guidelines due to the need to, let's say, assist data controllers in terms of accountability. But the new procedure within the GDPR about future guidelines by EDPS will be very different, at least in terms of public consultation. This is a big opportunity for you to interact more with this network of independent DPAs. But independent DPAs do not absorb the implementation of the GDPR, and so there is an issue of visibility before national courts, where I see a growing number of leading cases, not only related to data protection, but also to privacy in the traditional sense. So it would be a good idea to also establish, let's let's say, a simple database to monitor how the GDPR and the related national laws adopted after the GDPR would work. Essentially, it's also to have a reflection about the reuse of money you may get as a result of a collective redress mechanism. Regrettably, at least in my country, we had in the past very negative experiences of money improperly reused as a result of a non-transparent agreement with certain operators, particularly in the telecom area. So there is a lot of work, and I think it's time we synchronize more our action. Please consider the EDPS as, let's say, a good partner. About fake news, we have no time to enter into details. We interacted many times, at least twice, in 2012 and 2015. In 2015, as a result of a public consultation, and I think we share many of the comments I found in the recent position by EDRi, for instance, the lack of a definition of illegal content, the uncertainty about the borderline between what is simply harmful and what is illegal. The signals I see around Europe are very scattered and fragmented. Germany has intervened with let's say, a national approach which is considered a little bit problematic outside Germany. Sweden has established an independent body. Italy has reacted recently with a couple of initiatives, very criticized an establishment of a task force by the police, and therefore many others published articles by saying this is not a police-related issue. Another piece of legislation now provides a national level in my country of origin for a decision taken by the independent authority in the telecom area, in my view, in a very questionable way, according to the specific protection for the freedom of and secrecy of communication within our constitution, which only provides for an intervention by the judicial authority. So we see how different countries are approaching. Therefore, I can only endorse the proposal by EDRi and others for a European Union approach, which I do not expect during this mandate. I understand that the Commission will not adopt anything special after May, June this year, and therefore I think we will have time to, let's say, prepare the future. We will keep you informed about any additional position by us. Let me briefly draw your attention on the incoming Olympic Games on privacy data protection. We've been working for years to do it together with one sister authority, the one for Bulgaria. Why? Because they were expected to lead the presidency of the Council in the second semester, which is not anymore the case. It will be on the ethical dimension of not the data processing, on digital ethics as a whole. It will not be a blah 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 exercise. We are very ambitious. We know some skepticism by data protection colleagues saying that GDPR is a priority, but I will repeat for you my assumption. Data protection is an important piece of legislation, but does not provide all the answers to the challenges of the digital society. I would like to explore in that to which extent we may need of additional let's say, actions in terms of sustainability of certain data processing operation to analyze what is not only technically feasible but also morally tenable, and therefore we have to better analyze what is ethics in addition to data protection, not to replace data protection, not to weaken data protection principles. To extend ethics is already embedded within existing data protection rules. Who is entitled to speak about ethics? Which ethics? A global ethics, a sectoral one. We discussed around the world about the interoperability of different standards on data protection. It's more than 20 years. Why we should agree on ethical principles, but that's the challenge we would like to analyze together with data controllers. We will analyze the digital ethics also with regard to law enforcement, and we would like to better understand to which extent data controllers, government, legislators, civil society, and data controllers are, let's say, engaged and entitled to make these additional principles on ethics effective in practice. Be on board. We sent you a letter on 19th of December. It was addressed to the Global Civil Society Coalition as a whole. We invited you, in answering to your letter, we invited you to take an active role by, for instance, nominating a representative, a couple of persons to the advisory committee to share your ideas about the open session. It will not be based on panels, but on a lot of debates. It will be in the hemicycle of the European Parliament with a lot of microphones available to the public. We are discussing about reduced fees for the civil society as compared to previous editions. We are discussing about the idea to finance a few speakers from the civil society and to be of an help as EDPS with regard to your side events and logistical arrangements. We need an answer soon because time is running, and therefore you see that a few people from my staff is around. Hernani Chirazaro is the contact point for the letter. Don't be shy and be on board as soon as possible. What else? Thank you for your initiative. We have an EDPS family photo to be published in our annual report at 12:30 sharp in the European Parliament, so need to go together with Wojciech. Unless there is any burning question, once again, thank you for being around and hope to see you soon.